Thank you, Your Honor. I'm sorry, I was having a bit of technical difficulty. All right, can you see the PowerPoint still, Your Honor?
It was up and now it's back down.
Okay, now it's back down. Excellent. All right. So again, I think where we left off, it was that essentially what happened is because the city wanted a double frontage lot, they came up and determined that there was a third existing street or a third street. They made it up. It had never been there before. And I think you look at the evidence that was presented, which is number one, I mentioned this, that it's undisputed that the property is at a corner lot. That then requires, as a matter of law, the existence of a third street. And when you look at the evidence, here's the actual street sign. There's only two streets identified. And you notice in the left-hand corner of these street signs is the UP symbol. In I guess most places, especially in the court of law, that would be determined an admission against interest and should probably be the end of this case. When you look at the DCAD property tax statements, you see that there are only two streets. There's Grassmere down here at the bottom, Grassmere at the turn, and then Hunter's Glen going north as well. This is the city's own map that they used in response to the summary judgment. It too only identifies two streets, Grassmere and Hunter's Glen. So this third street is imaginary, and it's just like other imaginary things, Santa Claus, unicorns, and the Easter Bunny, except while these are very harmless and they're fun, this actually worked great harm on the property owner. Because as Your Honor can see, if the setbacks are actually applied as drawn here, the buildable area is the pink space on this portion of the map. It takes this lot, which is a 0.85 acre lot, and gives a buildable area of approximately 25%, depriving the homeowner of 75% of what is available. Now, what the city tries to do is they try to take a definition from another location. And that's the second box that we have here, another location in the ordinance, where what they do is in order to determine whether or not a street is a corner, which the parties here stipulated, they have this reference to segments when they talk about segments of the same street, right? Or such segments. And they try to say that because this is a segment or a wide angle radius curve in a street, that it's a separate street. But that actually, that's not the part of the statute that we're dealing with, because we agreed that this was a corner lot. But even in the definition of this, to get a segment, it still has to be a segment of the same street. So that means we're continuing to deal with Grassmere or Hunter's Glen. There's only two streets. And so the only thing is whether or not it is a corner lot. We know it's a corner lot, but whether or not it has frontage on two or more streets. And everything says that there's only two, Grassmere and Hunter's Glen. And this is exactly, I showed you this case earlier. This is what the Glenrose case says. You can't write new words into and out of the zoning ordinance. And that's exactly what they're trying to do, is use segments or wide radius when the only thing they have to look at is whether there's more than two streets. Now, here's the last reason that I know that this is an abuse of discretion. The blue outline is the current structure, meaning the
I just
structure.
want you to know we can't see your PowerPoint.
All right, let me see. How about now? Can you see it?
See it. Yes.
Okay. All right. When did I lose you?
For a while, but that's okay. started talking about the blue area, and that's when I was kind of concerned because I don't remember seeing that in the briefing.
All right, hold on. I'm sorry. I don't know why I'm seeming to struggle a little bit here. Give me.
I can see your PowerPoint now, if that's helpful.
We can see it. Yeah, we can see it now, Mr. Cox.
Okay, but oddly, I can't. Okay. All right. Oh, you can see it now. Okay. Can you see the blue area right now?
Yes.
Okay. All right. So the blue outline is the current structure. And what I did is I telescoped into the pink section that we were looking at, right? The pink section on this slide is if this double frontage third imaginary street interpretation applies, the pink area is what the city says you can build on. But if you look at this, you can see in both the lower left-hand corner and in the right-hand side of this that the current existing structure exceeds the build lines. So there's no way that this has ever been an interpretation that applies to this property. So at the end of the day, because Texas law favors the property owner, because the board failed to apply the law correctly and came up or made up an imaginary third street that its own documents, its own history, and the prior owner's use of the property demonstrate are an abuse of discretion and violate the law. Moreover, the great harm, reducing by 75% the buildable area on this lot for the homeowner, this summary judgment should be granted and the city and the board's opinion should be reversed.
All right, response?
Thank you, Your Honor. Well, I'd like to start with the argument that Texas property rights favor property owners. That may be true, but as this court is well aware, that is subject to reasonable regulation of the regulating entity. And zoning ordinances have historically been found to be reasonable regulations. So the petitioner here, basically their arguments come down to one thing. The Board of Adjustments did not agree with them. That's it, plain and simple. The record returned in response to the writ shows that the board, in fact, did make its decision based on reasonable rules and principles, and including in that included.
Let me ask you this. So there's a reference in your briefing, a couple of references that I thought were interesting. One was that the vote on this was, I guess, 3 votes in favor of the petitioner and 2 votes in favor of the, I guess, the plan administrator or the plan department. But under the rules for the, I guess, the city ordinance, that it takes 4 out of 5 to overturn the city plan commission or the city planner's recommendation. Is that right?
Right, Your Honor. And that's actually state law in the local government code.
Okay.
It requires a 3/4 vote.
Okay. The next question I have is there is a reference that there have been other decisions in similar situations where the board had taken a similar position. Is that right?
Yes, Your Honor. In this case in particular is an appeal, but the in prior cases it was agreed a plan development, specifically, I believe that's 6801 Hunters Glen, or 6801 Hunters Glen, was a plan development where the parties agreed that the corner was a double frontage lot. And then in 60, let's see, it's a UP record. The prior decisions or prior cases, UP record 39 and 40 is the plan development in which the double frontage lot was recognized. UP record 41 was the other case.
I guess my question is
6815. I'm sorry. Go ahead.
my question is, did any of those other cases where a similar situation occurred, and you're kind of giving me some of this information, that any of those get appealed to a district court?
No, Your Honor. Those were, one was an agreement because it was a planned development, and the other one was from 1995, and that I believe was also by agreement.
Okay. And is that contained, are property owners able to see that? Like, is there some kind of record kept that when they purchased this home, they'd be able to know that this was the position of the city? Or is that, in other words, are there opinions like there is in courts?
There are not opinions like there are in courts. However, the record, the minutes, the planned development, all of these documents are available. They are government records. They are available from the city. Any, number of questions, any information that, okay, yes, that information would have been available from the city had the homeowner decide to ask for it. Yes.
Okay. And then the homeowner seems to be taking the position that under the city's interpretation of the double frontage, that their current house would be out of compliance. Is that accurate?
Your Honor, that is not accurate. The petitioner has no way to know that. That's a false argument, because this house was built 67 years ago, and we don't know what the regulations were at that time.
Okay.
So that's a false argument.
So essentially, this is really a fight over whether or not they get to build their fence.
Yes, Your Honor, that's what it boils down to. And the particular interesting point here is this property is addressed as Hunter's Glen, but the front door of this house for the past 67 years has been on Grassmere Lane. The city is not arguing it. We're not bringing up the fact that, the front door does not face the addressed street. But if their front door is going to continue to be on Grassmere Lane, then they are definitely trying to put a fence in their front yard. If their house is going to face on Hunter's Glen, where the front door is on Hunter's Glen, then that might be a different story. Basically, they're putting the cart before the horse, Your Honor. We need a plan. We need to know where is the house actually going to face? None of that has been submitted. All the city had at this time.
Maybe I misunderstood. I thought this was just they wanted to build the fence, or they wanted to tear down and rebuild the house too.
I don't know, Your Honor. That's the point. They filed an application for a fence permit. A planned development or something would have been any other request would have been more appropriate than a fence permit at this point.
Explain what you mean by that.
Well, Your Honor, so the house that's currently there, if that house is going to remain, the front door of that house is on Grassmere Lane. There's no dispute about that. So if the fence permit were approved, we'd be putting a fence in what is definitely a front yard. If they're going to tear that house down and face it on Hunter's Glen, then it's possible that, if the Board of Adjustments had decided that this was not a double frontage lot, that Grassmere would then become a side yard. However, based on the fact that whichever way you orient this house, this is not a regular corner, because the house will back up to the side of whatever house, whether it's the house to the, I believe that would be west, or the house to the north. The backyard of either one of those houses is going to be the side of this house, whichever way it's oriented. So that makes this corner different than most corners, because usually my house backs up to the back of the house behind me or an alley. That's not the case with this lot. So there are several things going on with this lot. And the reason that Director Baugh looked at the statute and actually went into some statutory construction was because this lot is so much different than other lots. The guiding principles were not just the statute. It has to be history here, Your Honor, because while Director Baugh may have stated that a board's prior decision is not binding on the city, Director Baugh is not an attorney. He's not competent to make a legal conclusion like that. So that's yet another false argument being asserted in this case. The other thing that the petitioner has repeatedly mentioned is their hardship. Well, the Vanesco case, the Landmark case makes it very clear that personal hardships are not to be considered. This is a personal hardship. It is irrelevant to the board's determination and to this court's determination. And the case law is clear that the construction, that while a legal conclusion of a board might not be entitled to deference, the construction placed on the statute by the agency interpreting that statute is entitled to great weight. And that is from the Seawall East Townhomes Association versus City of Galveston case cited by the petitioner. So then you look at the construction that the city went through and start with section 11.115, which is exhibit 2 to the plaintiff's petition and can be found at UP 000005, the definition of a lot. The very first, the way the statute is constructed, a lot is defined. And then we have lot, comma, double frontage, lot, comma, corner. So those are interpreted as subcategories of a lot. So it makes perfect sense that Director Baugh would look at all of those definitions and apply all of those definitions in making his determination. It's also relevant, very relevant, that this lot happens to be an incredibly irregular shape. And the irregular shape comes from the design of the entire neighborhood, which the corner at Grassmere and Hunter's Glen is not the only corner like this in the neighborhood. In fact, the corners at Druid and Hunter's Glen, Druid and Westwick, Vassar and Turtle Creek, and Baltimore and Turtle Creek, all are the same, in the same situation. And this map can be found at UP 00054 and Petitioner's Exhibit 12. The petitioner also wants to make much of the DCAD map, but the city, the Board of Adjustments also had before it several other maps that indicate that Hunter's Glen is at the very least a segmented street. If you look at
Ms. Morris, we're kind of running out of time, so let's kind of get to the final argument here.
Okay. Well, the bottom line is the board, the city's interpretation and the board's final decision was based on clear guidelines, guiding principles. The city director of public works, community services, explained all of this. It's in the transcript, how he reached his conclusions, provided several maps that show Grassmere to be actually a segmented street. And the original, one of those maps is the original subdivision map that is at page 60, I believe, of the writ response, which shows Grassmere at the fork to be North Grassmere Lane and South Grassmere Lane, indicating it is certainly a forked street that is capable of being considered 3 streets or segments of a street.
All right, let me just kind of, I actually have to finish this hearing. I'd like you to brief for me if you haven't already. I didn't see anything in there. Are there any cases in the state of Texas that interpret what double frontage means? Have you guys found anything that interpret that, or is that something a unique planning term to the city of University Park?
Your Honor, I don't believe there's any cases. It is in the ordinance that says on a corner lot, double frontage has to have more than 2 streets. There's nothing else other than that. And if I may be allowed a minute or 2 in rebuttal, Your Honor.
I'm not going to rule on this right now. I'm going to take it under advisement. I don't really have time. So I've read all this. I have a pretty good understanding. I've actually handled these kind of cases when I was in private practice. And so I'm going to take an advisement. We'll try to get you a decision within the next month. All right, guys.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
May we be excused, Your Honor?
You may be excused. Let's go to the next case, which is Nance v. Oyabande. Anyone here on that case?
Good morning, Your Honor. Eric Montrose here for defendant Oyabande.
Anyone else here on that?
Your Honor, Travis Bolts on behalf of Camilla Nance, defendant in one of the cases.
Okay. I've reviewed all this. Is there any, it seems kind of clear cut. Is there any opposition to consolidating this?
No, Your Honor.
Okay.
No, Your Honor.
Yeah. Just in the future, so you know, I hate you had to wait around here, that usually if you guys submit this as an agreed order to consolidate, this would have been just handled without a hearing. So because I do handle, that's how I generally do that. So it just kind of got to a hearing because it wasn't agreed to. So no worries. I'm not fussing with you, but just so I hate to have you guys waste your time. So just in the future, but I'll go ahead and sign the order to consolidate. We do need to set it for trial. So when do y'all want to set it for trial?
I think my calendar is locking up right now, but
Give me an approximate month. How much do you still need to do on the case?
we still have to do everything. We were waiting to consolidate so everyone was in one cause number.
Okay. Do you want to shoot for sometime next year, or what is your thoughts?
Next year is good for me.
That would be fine with me as well.
How far into next year?
I think March.
That should work.
March of next year. Okay. You want to do March 7th?
That should work for us.
Okay.
Just double check. Sorry. You said March 12th, Your Honor?
7th, March 7th.
Sorry. Yes, sir. Your Honor, that works for me as well.
Rhonda, go ahead. Are you there, Rhonda?
Yes, Judge.
Go ahead and set this consolidated case, which is DC 22-00402. Go ahead and set that for trial on March 7th, 2023.
Got it.
And who do you want to use as a mediator?
I like Karen Gammon.
I honestly haven't heard of her. If it's okay, Your Honor, we can shoot counsel a list, or do we need to agree to one today?
Otherwise I'm just going to appoint one. So who do you like, Mr. Bolts? Are you not from Dallas, Mr. Bolts?
No, I am, but relatively new at the firm. So
okay, yeah, Ms. Gammon has been around a long time.
Okay,
I'll give you 3 names. You each can veto one: Ken Rubenstein, Karen Gammon, and Mike McCullough.
I like all of those people.
Okay.
Would Mike McCullough be okay?
Yes.
All right, let's go ahead and appoint Mike McCullough on this one, Rhonda.
Got it.
All right, and just try to get this mediated when you can. And Rhonda, go ahead and get him as the mediator.
Will do.
All right, thank you, guys. We'll get this order scanned in and hopefully be entered today, okay?
Thank you, Your Honor. Are we excused?
You are excused. Sorry for the delay.
Thank you,
No
Your
problem.
Honor.
Bye, everyone.
Thank you, guys. All right, next case up is Dallas Oil Service, Inc. versus Mulholland. Anyone here in that case?
Yes, good morning, Your Honor. Eric Wood for the defendant, Stephen Mulholland.
Yes, Your Honor. John Naus here for Dallas Oil plaintiff.
All right, Tony, let's go on the record on DC 2016971, Dallas Oil Service, Inc. versus Stephen James Mulholland. Counsel, make your appearances.
Morning, Your Honor. Eric
Your Honor,
Wood,
John
Brown
Naus.
Fox.
I'm here for Dallas Oil. Sorry.
Eric Wood with Brown Fox for the defendant and movant, Stephen James Mulholland.
John Naus, Your Honor, here for plaintiff and respondent here for Dallas Oil.
All right, I've already ruled on this one, so kind of let's just get right to the nitty gritty. Why should I overturn my previous ruling?
Yes, Your Honor. Good morning. Just a couple reasons. One, Your Honor, I'm obviously you've had hundreds of hearings since last January, but my recollection of the hearing last January was, as you know, there's a companion case that we call where another similarly situated defendant named Shannon Neptune was sued in another court in Dallas based on the same contract, same allegations, same customers allegedly lost. And at the time, we had filed a motion for summary judgment in that case, and it had been denied. And when we had our hearing in this case in January, plaintiff's counsel relied heavily on that and arguing, hey, these cases are identical. If that court found a fact issue, there's got to be one here too. Therefore, you should deny the motion. And the motion was in fact denied at that time. But I also recall, Your Honor, referencing that you might reconsider the legal arguments prior to trial. And so that's what we're here to do this morning. And then finally, we also did not get a written ruling on any of the objections to the summary judgment evidence that had been filed. I don't think you even need to get there if you consider the legal argument that I'm about to address. But if you do, then I think we need to go through the affidavit and show why the affidavit of Mr. Slaughter, why it's objectionable.
Unfortunately, this post-COVID era, we don't have a lot of time. So can you just hit the high points on the legal argument?
Sure. Yeah, sure. First and foremost, this is a case involving non-compete, as you know, and there was a full evidentiary hearing on the temporary injunction in the other case on Mr. Neptune, same contract again. And Judge Smith found that contract was unreasonable in scope and reformed it from 5 years to 1 year and only within 150 miles. Based on that ruling, we entered it into instead of having a full-blown injunction hearing in this case, opposing counsel and I entered into proposed an agreed injunction to Your Honor, which likewise reformed Mr. Mulholland's agreement. And Your Honor signed that. And in fact, the order actually says the court is reforming it. So I have it right here. The word reform is used. So, and under section 15.51C of the Texas Business Commerce Code, if the court reforms an agreement, a non-competition agreement, because it's unreasonable, the court may not award damages for any breaches that predated reformation, period. The only evidence of any alleged breaches and any alleged damages that the plaintiff has suffered were for alleged breaches that occurred prior to reformation. There have been no allegations or proof of any alleged breaches post-reformation in December of 2020. Now, the only argument that plaintiff raises, he doesn't dispute that there's no evidence of anything after that. The only argument raised in response to our motion was, well, we didn't have a full-blown temporary injunction hearing, therefore that law doesn't apply. But there's no case law that supports that argument. statute says what it says. If the court has to reform it, you cannot get judged. You cannot get damages for any pre-reformation breaches. That happened here, regardless of whether it was based on an agreement or not. Clearly, the plaintiff did so because he had already found, one court had already found it to be unreasonable. So we believe under the plain language of the statute, the claims must be dismissed because there's no allegations or proof of any breaches that postdated. Moreover, Your Honor, even if that law didn't apply, the quote unquote evidence of damages is fatally flawed for a plethora of reasons. It's completely conclusory. Mr. Slaughter does not provide any evidence whatsoever as to why any of these alleged customers left. He makes statements with regard to what he allegedly was told by customers, doesn't even identify what who those customers are when he spoke to them, and it's clearly hearsay. Then he just says, well, then I've lost $180,000 in gross revenues. Well, gross revenues isn't even the proper measure of damages. It's profits, and he provides no evidence of net profits. It's only gross revenues. So for these reasons, Your Honor, we think that the motion should have been granted and should be granted now, dismissing all of the claims against Mr. Mulholland. There's simply nothing left to go to trial on in this case. There are no fact issues. As a matter of law, the claims against him failed. Thank you.
All right, response?
Your Honor, our response is that 1551C does not even apply. What it requires and what actually 1551B requires is that the burden is on the promisor, in this case Mulholland, to prove by preponderance of evidence that the covenant not to compete was not reasonable as to geographic reasons or time. We had no hearing. He waived a hearing and you'll find that in the order. What the court did, because there was no hearing whatsoever, made no findings. There was no evidence presented by the promisor. He simply agreed, in fact, waived the hearing on that, just as he waived the hearing on his objections. He had a duty to request a hearing, didn't do that, didn't have any type of finding on that either. Now what he wants the court to do is retroactively go back and redo all of his objections, which the court never addressed because he waived it, and now say, oh, well, we'll retroactively consider everything on the motion for summary judgment, which you correctly determined. The case of Neptune is completely distinguishable. They had a full evidentiary hearing and there was a finding by the court in that case. There was not in this case. The court simply approved an agreed order. What he doesn't mention is under 1551A, it specifically provides that the court can, if he finds a breach of a covenant not to compete, grant both damages and injunctive relief. C simply restricts it if there is a finding by the court that it's unreasonable. That didn't happen here. What he also says it's not true is he says that the court relied we relied primarily on Ernie Slaughter's affidavit. What we had here, Your Honor, was a deposition where the defendant, Mulholland, admitted to breaching the covenant not to compete by contacting 21 customers, further admitted that he solicited 16, which were lost to my client. There was specific evidence presented by my client, Ernie Slaughter, who is the president of Dallas Oil, as to the exact amount that was lost for each customer, how many gallons were lost, with the figure of 95 cents per gallon, how much was lost total. So the evidence was absolutely overwhelming. The court completely did what the court should have done and denied the motions for summary judgment. Also, we have not one but two causes of action, not just breach of contract. We have tortuous interference with contracts. So 1551 doesn't apply to that. So I think it's completely distinguishable, Your Honor. I think you were correct. We're set for trial on the 7th. We're ready.
On June 7th?
Yes.
Okay. All right. Both of you guys get me proposed orders on this as soon as you can. I'm going to take this under advisement. And are you guys ready for trial on June 7th, assuming I deny the wish of reconsideration?
Yes, sir.
Well, Your Honor, we believe we were ordered to mediate, and that has not happened. So I would state that we're going to have to get that. Obviously, you're going to want us to do that before trial, and that's less than 2 weeks away. So my hope is that you're going to grant the motion, but if not, I think we will have to ask you to move the trial date so that we can get the mediation scheduled as we were required to do. That has not happened yet.
We're fine with that, Your Honor. If the court orders it, we'll do it.
Okay. I will get you a ruling as soon as possible, and go ahead and give me a motion for continuance if that's what you'd like to do. It's unlikely. We're not reaching many. This is a 2020 case, as I recall. We're not reaching a whole lot of those right now anyway, but given the backlog, but we're doing our best. So we'll get you a decision as soon as possible, but please, when you submit the order, put it as plain on the top, put it as plaintiff's proposed order regarding May 23rd hearing. And then for the defendant, put defendant's proposed order on the very top, and then get that to me by the end of the day.
Your Honor, I think both of us have submitted orders, proposed orders.
Okay.
Already.
All right. Thank you so much. You guys have a great rest of your day. Okay.
Thank you, sir.
Thank you.
Our next case is the motion to consolidate in Baba Brooklyn versus Don Willems. Are both sides here for that? All right, is anyone here for that case? Okay. How about Garcia versus Penhall Company? Anyone here for that case?
Yes, Your Honor.
Yes, Your Honor. Reagan Sahady for the plaintiffs. I think that's Mr. Donahue, and they just said he's here as well.
That's correct. For defendants.
All right, and you're under iPhone?
Michael Donahue is. Yes, Your Honor. I apologize.
Okay, I've read this. So has the case been to mediation already?
No, Your Honor.
And why not?
It needs to go to mediation. I'll say that. I think Kelly Curran is the appointed mediator.
Is that right?
That's correct, Judge.
Okay. And when is the case set for trial?
June 7th, Judge.
Mr. Donahue, do you want to try to get this case mediated between now and June 7th, or kind of what's the story?
I do want to get the case mediated. If we can get it mediated, that's fine. I don't know if the court is going to put us to trial on June the 7th, then obviously we want it mediated beforehand.
I mean, typically on a case of this age, I would normally grant a continuance if it's agreed to. It's kind of unusual on a car wreck case, it wouldn't be agreed to, but Mr. Donahue, you were the one opposed, correct?
We did object to it. Yes.
And what is the basis? Just that you want to go to trial?
Well, it's from what I see, it looks like the plaintiff is getting treated at a somewhat late hour, is what we're seeing. And I know part of their basis for asking for continuance is they say surgery is needed. And we just got an expert report here at the beginning of this month that was dated at the latter part of April for the first time. So it's kind of late in the game for this plaintiff to be treating and for this this doctor to be recommending surgery.
I mean, it happens. It's up to a jury to determine whether or not they believe it's related. Let's go ahead and reset this. when do you want, Mr. Sahidi, when is your proposal to reset this?
Judge, I'm amazed you got my name right on how to say it. Nobody does, but Sahadi is the right way to do it. But we said in the motion October, that may be a little bit premature. I'm thinking more in the January, February timeframe. There are some other things to do other than just get the medical worked up. We were trying to figure out just why the driver of the 18-wheeler just lost control, went into a closed lane. We know why, but we want to know the history of it and what the company knew, because he had taken a previous medical leave. So there's some more discovery to do on that front. So in that time frame is what I'm thinking, but Mr. Donahue can chime in to see what we want to do.
So I'm sorry, Reagan. What time frame are you thinking?
I said the January, February timeframe of 2023.
I'll say that those dates are open on my calendar, but if the court has that. The fact that this expert's been designated, or at least the report's come in so late, I mean, we too are going to have to, if this is continued, designate our own expert, obviously. So yes, Your Honor, the February, February timeframe of 2023 is workable for us.
Judge, you're muted, Your Honor.
Does February 28th or 21st work?
That's fine from the plaintiff's, Judge.
It works on our calendar, Your Honor.
All right, let's do February 28th. We do trials on Tuesday, and make sure that you go to mediation before then. And anything else today, guys?
Nothing from the plaintiff's, Judge.
Nothing more from defendants, Your Honor.
Okay, guys. All right, you guys are excused. I'll sign the order and we'll get it out today. Rhonda, go ahead and reset that to February 23rd.
Will do.
Or whatever date I just said. Okay.
28. Thanks, Judge.
28th. All right.
Thank you.
Okay, I think we're here on, no one else showed up on Bob of Brooklyn. Okay. Fisher v. Fisher. I think I've seen both sides here. Tony, let's go on the record on DC 1917340, Fisher v. Fisher. Counsel, make your appearances.
Mike Lynn's here, as well as for Mrs. Fisher.
All right. Larry Friedman and Seymour Roberts for Mr. Fisher and Fisher and Company.
Alan Lowenson for defendants Larry Teal and Ted Uzelak.
Ryan Shields here on behalf of Cliff Fisher and Fisher and Company.
Robert Epstein here on behalf of Cliff Fisher, but I represent him in the family lawsuit, so I'm really just observing.
Okay. And is the auditor here? The auditor is going to be here. Okay. Mr. Smith, you're not here?
No, Mr. Smith's not here, Judge. The hearing that involves the auditor's report is at 2:30 this afternoon.
Ah, okay. So which hearing is right now then?
The hearing is on defendant's amended motion for leave to file motions for summary judgment.
Okay. I've reviewed that. Let's go ahead and hear argument on that.
This is Larry Friedman. May it please the court. If you recall, the scheduling order in this case designated that all dispositive motions to be filed on March 28th, 2022. Previously, the auditor's report was due on January 31st, 2022. And then if you also recall, the court extended it, the due date on the auditor's report to February 28th, 2022. Now, at that point, Gail Fisher had 30 days to object to the auditor's report. So the auditor's report didn't really become final until March 28th, 2022, of course, subject to any objections that Gail Fisher made. Gail Fisher made no objections. So the auditor's report came final on March 28th, 2022, which was the same date that all dispositive motions were due. We didn't have a chance to update the summary judgments motions that were on file and file a new summary judgment motion based upon Mrs. Fisher's 6th amended petition, which you allowed her to file. So we would like to, we're requesting the court that we file a motion for summary judgment that's on file, our no evidence motion for summary judgment, and a new summary judgment regarding the 6th amended petition that Mrs. Fisher filed. Also, I think we have on file a motion for summary judgment regarding judicial notice and order entered. So we'd like to be able to file and reset all these motions. And frankly, Your Honor, based upon the auditor's report, which deemed every single allegation that Mrs. Fisher made in her petition, deemed it, we were no build. In other words, there were no evidence supporting her claims. We think that disposes of the entire case.
Okay.
Your Honor, before Mr. Lynn, we've joined in this motion. So when Mr. Friedman's finished, I've just got a brief comment.
Mr. Friedman, are you done?
Finish.
Mr. Lowenson?
On behalf of my clients, we joined in this motion. It was brought jointly, so I'm not going to waste the court's time incorporating. I will incorporate, rather than repeating what Mr. Friedman and his office have filed and argued to the court. I'd simply say that my clients will be severely prejudiced if, given the facts as we now find them, we cannot bring dispositive motions at this point because we believe those dispositive motions are going to show that the claims have been.
Mr. Lowenson, remind me, which version is it that it adds the breach of fiduciary duty related to the family court hearing? Is that the 6th or 7th?
The 6th.
It's the 6th. And I've already granted leave to allow them to pursue the 6th.
Yes, we have an order submitted to the court. I don't know if it's been signed, but there is an order.
Let me answer that. There is no version that adds any claims. Let me refer you to Mrs. Fisher's motion for leave to file the 6th amended petition. Because in that motion, Mrs. Fisher says in paragraph 6, the 6th amended petition eliminates 4 claims present in the 5th amended petition to more accurately reflect the current posture of the case. Then in paragraph 7, it says, importantly, Gail's proposed 6th amended petition does not seek to radically alter or transform the currently pending litigation. Instead, it solely aims to clarify, streamline, and more cogently detail the claims, here's the important language, already pending against defendant. And then in paragraph 12, Gail says, Gail's proposed 6th amendment does none of the above. It adds no new causes of action and instead solely recasts the allegations present in Gail's 5th amended petition. So if you go by what the argument that Gail Fisher made in order to persuade the court to allow her to file the 6th amended petition simply to streamline things and eliminate causes of action, there are no new claims of breach of fiduciary duty. There are just old claims, the same claims in the 5th Amendment that were streamlined. Additional notice of Gail Carter Fisher's motion for leave to file 6th amended petition. Please.
Okay. So the court will take judicial notice.
Can I get a ruling?
Yes.
Yes, Your Honor. So let me see if I can recast this and talk about the state of play that we're in. We got into this case in December. I was read 2 hours a day until the end of January to try to catch up. At which point we filed a motion for leave to amend the Sixth Amended. And I also reached agreement with Mr. Friedman and Mr. Lawson to extend and continue the trial date for 8.5 months until November, where we would go to trial. The new petition deals with the fiduciary duties that were created post-divorce and the relationship that gives rise to that. And there has been zero challenge to those pleadings. So they are the live pleadings before Your Honor. We have sought a new pretrial scheduling order, and I've had discussions with both Seymour and with Mr. Friedman about a overarching pretrial scheduling order that would permit us to develop the case in a way that would make sense given the allegations that are now before you. That would have the discovery cutoffs, the expert cutoffs, the normal things that one would have in a case for the next 8.5 months, so we could actually get this case ready for that November trial setting that everybody agreed to. And I have been rejected. I've been told over and over again that they're not going to agree to that. However, what they have done in this motion is say, you know, we want a mulligan, we want a King's X on that motion, on the present pretrial scheduling order as it relates to one item, our summary judgment. So they want a one-off to get a change in the pretrial scheduling order when it benefits them, but they don't want to deal with the overall architecture and what this court, I think, anticipated when it granted the Sixth Amended and when the parties agreed to an 8.5 month continuance. Now, I don't often cite this, but Rule 1 of the Texas Rules of Procedure oftentimes is, we read over it and we don't even take a look at it anymore. But Rule 1 is the foundation for everything else. Rule 1 is what the rules are based upon. And it says we are supposed to give liberal construction to the rules to obtain a fair and just, equitable and impartial adjudication of the rights of litigants under established principles of substantive law. That's what we're supposed to be doing here. So we've asked and we've sought from the outset nothing more than what a normal litigant would get in your court. And in my professional life, before Your Honor, you have never not given that.
Mr. Lynn, the problem is that I don't think you've ever entered a case in the ninth inning. I mean, you kind of entered the case in the ninth inning.
It's not, it may be the ninth inning, as I said, in the third game of the World Series, but it's not over.
It's the bottom of the ninth.
And it is not, let me finish. It is not, that Sixth Amendment I am proud of. I think that I can take that and I can win that before a jury. Now, this audit report, which they give so much credence to, you may remember that you granted that auditors over our objection. And then that audit, we don't believe that it's a proper auditor's report or audit order, because if you read the rules, those rules, it specifically talks about basically adding and subtracting for purposes of determining invoices or determining things that relate to what an auditor normally does. What you just heard Mr. Friedman say, and what Mr. Seymour has written in his briefs, is it rules on a whole bunch of substantive issues. For example, whether or not the distributions that were made to us were equal. They weren't. We have our own experts that have gone through the records, and we now know that there has been a complete violation of the distribution order, and that is a breach of fiduciary duty because it deals with post-divorce conduct, which the mandamus order said is properly before Your Honor. And then we go in and we've cited the cases and we have a live pleading that alleges that. And what's more, Your Honor, what is unfair about that order and what Mr. Friedman is trying to do is bootstrap basically a summary judgment off of a hearsay document, because we were given, according to you, the right to all of the substantive documents, that man, the auditor, relied upon. They have never been delivered to us, none of them. Zero. I've talked to him on multiple.
Mr. Lynn, didn't you wait 29 days before requesting them though?
Right. I waited and asked for them on the final day, I think. But remember how this all came about. When I asked him for them, I actually called earlier and asked for them.
I think we're kind of let's just do this. I think we're bleeding into the next hearing at this point. I think all of these kind of make sense. I want to hear from the auditor. Got to get a sense of what is going on. I know there's a request to abate the case. There's also other motions as well that relate to this. I think they kind of work better if they're all kind of decided together.
Judge, may I just correct Mr. Lynn on a few matters that he stated that I think are incorrect, and I want the record to reflect that they are correct in the way that I am stating them.
Okay.
Mr. Lynn said he got into the case in December. He filed his notice of appearance on November 18th. So he got into this case in mid-November. If you look at the scheduling order, he had 74 days to conduct fact discovery. I'm not aware that he conducted any fact discovery. He had between 74 and 116 days to file various notices of an expert witness, either for affirmative defenses or to make his case. He never did that. So he had a lot of time to do all of these things, and he didn't do them. My client, on the other hand, conducted fact discovery.
I'm not hearing Mr. Robert.
What?
I can hear you fine.
Okay. My client, conducted fact discovery.
I'm not hearing Mr. Roberts. Is anyone having that problem?
I'm hearing.
I hear.
I hear him.
Okay. My client conducted fact discovery. My client designated expert witnesses. My client did all these things. Mr. Lynn had the helm for months and did not do any of those things. And now, after the fact, he is saying, "Oh, well, I want the mulligan. I want the brass ring." But the problem is that he could have filed his motions. He could have done things much earlier and did not. And that's what
Mr. Roberts, I read all your briefing on that. And that's why I made the comment I did about to Mr. Lynn, is that he's joined in the ninth inning and he waited 29 days to file this. Those are all serious concerns, but I do think it needs to be decided in context. This motion needs to be decided in context of the rest of the motions that are being filed. I don't think that it makes sense to decide this one issue when there's a pending abatement motion and the other motions that have been filed. And so I want to decide this all together. So, but I appreciate what you're saying, Mr. Roberts. Why don't we, I will see you back at 2:30 and we'll hopefully make a decision on that stuff then. Okay, guys?
Thank you.
Yes, Your Honor.
Thank you.
Looking forward to it.
And Mr. Friedman, your connection isn't very good, so you might want to work. I don't know where you are right now, but you need to work on your Wi-Fi. It's hard to hear you.
Just sitting in my office here in North Dallas.
Okay. Well, anyway, just I want to get it checked.
Thank you.
Thank you. Interns, wait around. Oops. Go ahead.